Hello, everyone, and welcome to another of our ongoing series of webinars on antitrust topics of interest to the business community. I'm Chuck Laughlin, a partner in our antitrust group here in Washington, D.C., and the former chief trial counsel for the FTC. Let me first begin with a few housekeeping items. First, this webinar is being recorded. The link to the recording and slides will be distributed via email to all participants. Recordings of past webinars are also available. You can find them on the Hogan Lovells website under the subpage titled Events and Webinars. Second, this webinar will count for one CLE credit. We will announce the CLE code later, and the appropriate forms are available to download in the reminder email that was sent yesterday. We'll also resend the forms after the webinar has concluded. Third, we hope to leave some time at the end for questions. If you want to submit a question, please do so using the Q&A button on the bottom of your screen. So with me today, we have a great panel. First, Alana Patan is a counsel in our antitrust group here in Washington, D.C. Alana advises clients on merger review, conduct investigations before the antitrust agencies, and provides counseling on a wide variety of antitrust issues. We also have Chris Fitzpatrick, who's a senior associate in our antitrust group based here again in Washington, D.C. Chris handles both domestic and cross-border competition disputes and advises clients on all manner of antitrust compliance issues. Third, we have Dr. Julian Urban. Julian is a senior associate in our Dusseldorf office, and Julian advises clients on all areas of the EU competition law, including merger control proceedings, cartel investigations, competition compliance, and competition disputes. So thank you all for joining us today. Our webinar is called AI Trends and Antitrust, What You Need to Know. And this is a very hot topic in antitrust right now. The U.S. agencies are very active in it, particularly in terms of the use of pricing algorithms by companies. They've written a number of amicus briefs on the topic, given speeches about it. But AI is frankly a new thing, and how antitrust applies to it is relatively new too. So there's a lot to talk about today. And let me start just by asking each of our panelists to give a quick overview of the issues that they see related to AI and antitrust. And Chris, let me start with you.
Thanks, Chuck. There are a number of concerns that the regulators are articulating in this space. And in the competition sphere, these can generally be thought of as falling into one of two buckets. The first is the potential for AI to harm competition across the entire economy. And the second is the potential for consolidation and reduced competition in AI-related markets themselves. And I want to focus initially on that first category, the perceived potential for harm across the economy. The rapid advancement in AI technology will impact all sectors, whether through the technology's influence on how firms market and price their products, its implications for labor markets, or the integration in everyday goods and services that consumers purchase. And because of this wide-ranging effect on the economy, the regulators are wary of potential anti-competitive effects that may flow from the tech. And three of their concerns in particular stand out. One prominent area of focus, as you mentioned, is algorithmic pricing, which regulator statements often lump in with these AI issues generally. The second is the use of AI tools for strategies such as self-preferencing or bundling goods and services in a way that could have anti-competitive effects. And the third is harms flowing from data aggregation and information exchange theories that are rooted in AI's ability to provide enhanced insights into firms' data. And I think we'll talk about each of these in more detail today. But throughout the discussion, it will be useful to keep in mind the agency's big picture perspective that is animating their concerns. The DOJ and the FTC are really looking back at a comparable technological leap, which was the start of the Web 2.0 era. And that's what launched the modern internet economy that we know today. And the regulators see that period from their viewpoint as a failure of competition regulation and an area where they believe that more should have been done. And that's not to say the agencies only see the possible downsides of AI, but they are highly alert to the negative implications and resolved not to repeat what they perceive as earlier mistakes in regulation in the digital space.
Thanks, Chris. Alana, how about you? Can you give a quick overview of the topics you think we should know about?
Yes, thanks, Chuck. Hi, everyone. From the perspective of the antitrust authorities in the US, which Chris touched on, AI and algorithms as well are both clear focus areas for the Federal Trade Commission and the Department of Justice. Both the FTC and the DOJ are expanding their hiring of tech experts. In February 2023, the FTC actually voted to establish and then launched an Office of Technology within the agency, which has dedicated staff and resources, all with the goal to strengthen in-house technical expertise. For example, the FTC is hiring so-called technologists in residence, and these are people that have at least 1 year of specialized technical experience in software engineering, design, technology research and policy, or product management and development. And the DOJ has also announced that it intends to expand the hiring of data scientists and analysts. In September 2023, DOJ economist Malika Krishna stated that the DOJ was increasing its hiring of AI, machine learning, and data science experts who have the expertise to be able to analyze source codes and algorithms. And DOJ is also focused on training existing staff to be able to analyze code and algorithms to be able to issue spot potential antitrust concerns. And there are several significant implications for businesses from these developments. The first one is that tech is going to be a continuing area of focus for the agencies, and that absolutely includes AI. Second implication is that more experienced DOJ staff may be able to identify areas that would otherwise go unnoticed by those without that deep expertise. And that means that there may be additional investigations and in litigations that can arise because of these capabilities. And third and finally, companies should really expect more targeted questions during merger investigations and other investigations, which reflects that greater expertise and knowledge in the technology.
Thanks, Alana. Now, Julian, can you just give us a quick overview of the EU perspective?
Sure. Thank you, Chuck. And similar to the US, AI is certainly one of the most relevant and discussed issues in EU antitrust law at the moment. And it is in the focus of the EU Commission and many other competition authorities in the EU and also this UK CMA. And there are two aspects that are relevant here that I would like to emphasize. First, there seems to be the perception in the EU that, and this includes authorities, that the EU hasn't kept pace in the digital sector and is instead dominated by US or Chinese players. And there seems to be a fear that this could happen again in the AI sector. And antitrust law, and this includes all its pillars we see here, is one of the perceived solutions to prevent this. And we already seen some competition authorities that have taken more general investigative measures to improve their understanding of the AI sector. For example, the UK CMA has just published a report on its investigation into AI foundation models, outlining its concerns in the AI sector, and that competition does not work as it should. And the European Commission and, for example, also the French Competition Authority have just issued public consultations with the aim of identifying the competitive landscape in the AI sector, and of course also potential concerns in this sector. But, and this is the second point I would like to make, it's not only antitrust law on which we will focus this webinar, but it's also closely related regulation like the Digital Markets Act, as well as the AI Act, that are becoming increasingly important, and that will also have a huge impact on the AI space.
Thanks, Julian. So with that overview in mind, let's dive a little bit deeper. And Chris, I'm going to go back to you. You had mentioned three primary concerns from the agencies regarding AI. One, algorithmic pricing. Two, potential anti-competitive strategies related to AI, such as self-preferencing, bundling, tying. And then third, data aggregation and information exchange. Can you just discuss the basic antitrust concerns with the first issue, meaning algorithmic pricing?
Yes, well, algorithmic pricing is just that. It's the use of an algorithm, essentially a coded set of instructions for a computer to perform calculations and data processing to recommend or set pricing or output levels for business. Price fixing between competitors, of course, is illegal under Section 1 of the Sherman Act. And the regulators want to use the antitrust laws to prohibit certain uses of these pricing algorithms. And the US agencies have described their position in public statements and litigation filings, and it essentially boils down to two key points. The first is that you can't use an algorithm to evade the law banning price fixing agreements or improper information exchanges. And the second is that an agreement to use shared pricing recommendations or an agreement to use the same algorithmic price tools can still be unlawful even where the putative co-conspirators retain some pricing discretion or deviate from the agreement on price. So far, algorithmic pricing theories of harm have not met with much success. Just last month, a federal court in Nevada dismissed with prejudice a class complaint that alleged a Section 1 price fixing claim against hotels on an algorithmic pricing theory. And the court emphasized that the failure to allege that these hotels agreed to be bound by the algorithm's recommended prices, as well as the fact that the algorithm at issue merely analyzed information about hotel rates that was publicly available, was key part of the decision. But the order did also note that allegations of an agreement among competitors to accept an algorithm's pricing recommendations could potentially survive a motion to dismiss. And earlier this year, a similar class case involving rental properties survived a motion to dismiss in part, but had its per se claims dismissed. And in dismissing the per se claims, the court emphasized defendants' deviation from algorithmic pricing decisions and the lack of allegations of binding and enforceable agreement on price among the alleged co-conspirators. And there are a number of ongoing cases regarding this issue, and so the law is fairly unsettled. It's a topic that's drawing significant attention from both of the agencies and from the plaintiffs' bar, so it is an area where companies should tread cautiously while the courts try to sort this out. What we can take away from now is that there are a number of potentially relevant factors. How does the algorithm work? On what data does it rely? Is that data public or non-public? And have the relevant companies agreed to use the same algorithm or agreed to accept the pricing recommendations that come from the algorithm? And it remains to be seen how these will be balanced, but there are some early indications in those cases I mentioned.
Thanks, Chris. So, Julian, let me turn to you. And what are the EU agencies' views on algorithmic pricing?
Again, similar to the US, the exchange of pricing information or even price fixing between competitors is one of the most serious infringements under, for example, Article 101 of the treaty, and competition authorities in the EU are generally keen to enforce it. And this also applies when AI comes into play. And we have already seen some cases in previous year where authorities have established that pricing collusion facilitated by AI can be caught under the prohibition on cartels. Let me give you two examples. The CMA fined several undertakings for agreeing not to undercut each other's prices for posters and frames, and which was implemented by using automated pricing software. And the European Commission fined consumer electronic companies for imposing fixed or minimum resale prices to their online retailers, which were again monitored by the use of sophisticated monitoring tools. However, there are also other type of cases that can be relevant here, so-called hub and spoke cartels, where competitors, for example, adopt the same AI provided by a third party to determine the price levels, or the use of the same data pool of a third party for their algorithmic pricing. And the third, maybe most exotic category of cases is collusion that is not only facilitated by AI, but rather actually decided and implemented by more powerful AI. This means by an autonomous decision of the AI. And determining who is liable in these cases of autonomous AI decision is obviously a much more complex puzzle for authorities. But this is my view, companies are very unlikely to be let off the hook from authorities in these cases.
Thanks, Julian. Alana, let me turn to you. Algorithmic pricing has gotten some attention from Congress, we've seen. What can you tell us about that?
Algorithmic pricing is definitely a hot topic, not just for antitrust lawyers, but also in Congress. There are at least two bills targeting algorithmic collusion that have been introduced just this year. One is the proposed Preventing Algorithmic Collusion Act of 2024. It was introduced by Senator Amy Klobuchar, along with co-sponsors Senators Ron Wyden, Dick Durbin, Peter Welch, Mazie Hirono, and Richard Blumenthal, and that was introduced on the last day of January 2024. The legislation would, if adopted, presume a price-fixing agreement under Section 1 of the Sherman Act, and that a defendant has engaged in unfair methods of competition under Section 5 of the Federal Trade Commission Act if direct competitors are sharing competitively sensitive information through a pricing algorithm to raise prices. The bill is intended to close what Senator Klobuchar referred to as a, quote, loophole in current law as applied to automated price setting algorithms. According to Senator Klobuchar, when multiple competitors are delegating their pricing decisions to the same algorithm, there may not be an agreement, but the use of the algorithm can have the same effect as a traditional price fixing agreement. The legislation would also require companies with more than $5 million in annual revenue that use or distribute pricing algorithms to disclose that fact to customers and to current or prospective employees. The legislation would give the FTC and the DOJ the ability to audit the pricing algorithm upon request if there are concerns that it could be harming consumers. The legislation will also ban companies from using or distributing a pricing algorithm that is incorporating or was trained with non-public competitor data. And it would also direct the Federal Trade Commission to study pricing algorithms and the impact of those algorithms on competition. The second piece of legislation is the Preventing the Algorithmic Facilitation of Rental Housing Cartels Act of 2024, introduced also on the last day of January of this year. Very, very similar cast of characters that introduced it. It was introduced by Senators Ron Wyden and Peter Welch, along with co-sponsors Amy Klobuchar, Bernie Sanders, Mazie Hirono, LaFonza Butler, Jeff Merkley, and Richard Blumenthal. And the bill itself makes it per se unlawful under Section 1 of the Sherman Act, and also a violation of Section 5 of the FTC Act for a rental property owner. So think of your basic apartment building, the owner of that building, to contract for the services of a company that is coordinating rental housing prices and supply information. So to contract for what they're calling a coordinator. The bill also makes it unlawful, including under Section 5 of the FTC Act, for a coordinator to facilitate an agreement not to compete among rental property owners with respect to residential dwelling units. And the bill makes it unlawful for coordinators to merge if the merger would create an appreciable risk of materially lessening competition under Section 7, or if it would tend to create a monopoly or a monopsony. The provisions of this bill themselves are enforceable by the Federal Trade Commission, the DOJ, state attorneys general, and also any private individual that's been harmed. In general, both of these bills are driven by concerns of legislators that existing antitrust law may fall short when it comes to stopping algorithmic collusion. But their prospects are limited. The bills are unlikely to pass and become law. Neither of these two Senate bills has a single Republican co-sponsor, and there are no related bills in the House of Representatives. We do not expect that the House Judiciary Committee under Rep. Jim Jordan, we don't expect the House Judiciary Committee under his leadership to seek to pass any major antitrust reforms this year.
Thanks, Alana. So, Chris, let's switch away from algorithmic pricing to the second antitrust concern that you mentioned, which was potential anti-competitive strategies related to the use of AI. And you mentioned self-preferencing, bundling, tying. Can you explain what the basic antitrust theory is here?
Sure. So as to self-preferencing, the concern is that AI could supercharge a seller's ability to promote its own products and services over that of competitors in a way that could conceivably harm competition. For example, regulators might be wary of scenarios where firms with significant market power use unique AI-driven insights available to them to help drive customers to that firm and not others, whether through marketing, pricing strategies, et cetera. And this is a developing area of the law without a great deal of certainty. But the issue is one with heightened antitrust risk given the regulators' increasing scrutiny. It's an issue that has arisen in White House working groups, regulator statements, and the congressional record. So it is certainly something that businesses and the lawyers that advise them should be aware of. With respect to bundling and tying, it's really just application of those traditional antitrust concerns to the AI space. The concern the FTC has articulated is the potential for tech market leaders to foreclose competition by leveraging market power that they have. And a hypothetical example that the FTC has provided is the possibility of bundling AI applications with other tech products to harm the competitive strength of competing standalone AI offerings. So that is a company potentially linking together new AI applications with existing core popular products to reduce its competitors' ability to compete on the basis of the AI tech alone. So again, the typical antitrust analysis should apply here, but there may be heightened risk of attention from regulators and the plaintiffs' bar given the agency's focus on these issues.
Great, thanks, Chris. So, Julian, are those same concerns shared by the EU competition authorities?
The short answer is yes. The long answer is, as mentioned in the beginning, competition authorities in the EU are generally concerned that barriers to entry for innovative new AI startups could increase and that the AI sector could become dominated by a few players in the future. And in this context, the authorities pay particular attention to bundling and tying or self-preferencing as a potential abuse of dominance under Article 102 of the treaty. And these practices in particular, as Chris also just explained, can lead to the leverage of market power and also market foreclosure. The basics are, according to EU decision-making practice, a company is generally considered dominant when its market shares exceeds 50%, although in the digital sector, other factors can be relevant as well, for example, access to data. And we also have seen a large body of case law that prohibits bundling and tying of different products, unless it is a commercial practice or it creates efficiency that are passed on to consumers. And we have seen many high-profile cases of bundling and tying in the digital sector, starting in the early 2000s. And I think it may be just a matter of time before we see cases directly related to AI. And my feeling is that the European Commission or also other authorities in the EU are just waiting for the right landmark case to set a precedent. And some hypothetical relevant cases may be a dominant cloud service provider bundling its cloud services with its own AI services, making it harder for competing AI services without a cloud infrastructure to compete. Or another example, as Chris also just mentioned, it could be where a dominant AI provider bundles its various AI service into a multi-service offering to the detriment of smaller standalone AI businesses. And also, unlike the US, we have already seen some landmark cases of self-preferencing via algorithmic selection in the EU, also resulting in large fines and decision by authorities to stop such behavior. And maybe just as a final remark, we also see in the EU a great willingness of the competition authorities to explore also new or rather unconventional theories of harm. For example, the exploitation through data collection and combination, or also, and this at least is my view, the refusal of access to data, which will become highly important in the future, either for companies seeking access to data or for those companies that trying to protect their data.
Thanks, Julian. I appreciate that insight. Chris, let me get back to you and address the third sort of primary concern that you had mentioned which was related to data aggregation and information exchange. Can you describe the general antitrust concern there?
Well, the concern from the agency's perspective is that AI, particularly in combination with ever-increasing depth and breadth of data sets, may be able to provide greater competitive insights into data than was previously possible. Regulators believe that AI is unlocking the power of this data in a game-changing way, which is increasing the competitive value of historical or aggregated data from which firms can gain competitive insights they previously couldn't. And at the same time, the FTC and DOJ have withdrawn previously established guidance on information exchanges. So the risk here may be substantial. Businesses should be aware that old safe harbors and time-worn practices about information sharing or benchmarking practices may not evade regulator scrutiny in the AI era. There's been a particular focus on the use of intermediaries to exchange or publish information. And we've seen these intermediary information exchange investigations and litigation matters arise in a number of industries, notably including the agricultural industry, home rentals, and hotels. In general, when thinking about these issues, there are some guideposts to keep in mind. One is the nature of the information exchange. That's critical. It is risky if it's information focused on price, output, wages or compensation, or future business plans that are confidential. Older information is typically less risky, but it's important to note that what is old depends on the industry. Old in high frequency trading may not be the same as old in slower moving traditional industries. So current and forward looking information is of course the most significant concern. And information exchanges that are limited to competitors or otherwise non-public can also draw increased scrutiny. That said, this is a complex and developing issue, and information exchange questions should be raised with Competition Counsel on a case-by-case basis. There's sort of another note of how regulators have been thinking about AI and its interaction with big data that's separate from these information exchange theories, and that's their fear that AI tools and the accumulation of data could allow firms to gain or to maintain an unfair advantage over smaller competitors in the creation of digital content. And the regulators seem to be thinking that there is a significant economic importance in this digital content that could be subject to harm as a result of AI's influence on the marketplace. And they fear that consolidation over AI tools or over the data that feeds generative AI products could impede competition in these sort of creative endeavors.
Interesting. Thanks, Chris. Julian, anything to add to that from the EU perspective?
Maybe that this is certainly also on the radar of EU competition authorities. Authorities are well aware of the importance of data and potential concerns around information sharing. We've seen cases where competition authorities have been concerned about the use of non-public data collected on a platform for the platform's own business strategy. And of course, as Chris also just mentioned, the exchange of sensitive information over a platform or through a common AI risks violating EU antitrust law, which the Commission now explicitly states in its updated horizontal guidelines. But maybe, and this is important to mention here, there are also decisions by authorities where companies have been allowed actually to share data within, for example, data networks, industrial data networks to facilitate innovation. So there is some leeway for companies here as well.
Okay, great. Good to know. Thanks, Julian. So another issue that we often hear about when the agencies are speaking about AI is consolidation in AI-related market themselves. And Chris, can you tell us a little more about what the agencies are concerned with in terms of consolidation of AI markets?
Well, it's certainly been an area of focus. I think first is a concern about consolidation generally in the industry. The regulators' public statements make clear that M&A activity in the AI space is going to be closely scrutinized. They are worried about the competitive impact of AI, particularly advanced AI models, being developed within what they perceive to be a narrow set of companies. And this can go beyond the idea of traditional acquisitions. Regulators in the US and across the world are taking a close look at other forms of investments and partnerships between AI companies and larger tech industry players. In January of this year, for example, the FTC launched a 6B investigation into generative AI investments and partnerships, apparently assessing the competitive impact of collaborations between various tech firms and AI labs. And last week, it was reported that the FTC and DOJ have reached a deal to divvy up responsibilities for industry investigations. Regulator statements also suggest increasing attention into interlocking directorates in the AI industry and tech more generally. And that describes a situation where competitors with resources above a certain statutory threshold share one or more members of board of directors. And the underlying issue here is the potential for those individuals to facilitate information sharing between competitors or to impact decision-making of both firms in a way that is inconsistent with competition. So the takeaway here is that regardless of whether there's a formal merger or a significant investment of capital, companies should be aware that all sorts of relationships that touch on AI companies and AI technology may be subject to regulator attention. And critically, aside from consolidation among companies, the regulators are also signaling attention to control over key inputs to AI. One, as Julian mentioned from the EU perspective, is certainly data. Others include computing power, coding talent, the labor force that is developing these new AI technologies, and also in chipsets. And the regulators are looking at competition across the whole AI stack, every element that goes into the tech, from the user to the coder, all across the technology. And so merger activity, investments, partnerships, anything like that that touches these spaces are going to be subject to the same risk of regulator attention.
And Julian, do the EU competition authorities share that same concern?
Yes, absolutely. And I think we again see a lot of similarities between the US and the EU. The view of EU competition authorities seems to be that merger control has been too lax in the past and that many gap cases have escaped merger control. And they seem to fear that this could happen again with AI. And as we see on the slide here, the perceived gap cases, one is mergers involving an ecosystem. And this includes the acquisition of an AI startup by an incumbent, for example, with a large ecosystem of connected products, and which may then incorporate the AI technology or AI-based service of the target into its offering, leveraging and strengthening its overall market position. It's the so-called ecosystem theory of harm, and it's highly discussed at the moment. But the authorities are also concerned about killer acquisitions. This means an incumbent that acquires a competing target, not only to eliminate its market presence, but also to acquire technology, data, know-how, and also in particular high-skilled AI engineers. So there are similar concerns as in the US, and also similar to the US, we also see partnerships and strategic investments being more closely scrutinized. In these partnerships, usually the AI company receives funding or access to critical infrastructure such as cloud or data storage, and the financing party can usually use the AI technology or get some influence over the AI company or a minority stake. And if we go to the next slide, we see the perceived problems with these, according to EU authorities, is that these mergers often escape merge control because they do not meet the relevant thresholds, in particular those that are based on turnover, given that the targets are usually startups. And in response to this, we see some member states, Germany and Austria, have introduced thresholds based on the transaction value. Others, and this is a fairly new development, have introduced ex officio merger control, for example, Italy, and the Netherlands likely will introduce it. And most notably, the European Commission has implemented a new referral policy under Article 22 ECMR of reviewing deals that have been referred by member states to the European Commission. Even neither the European Commission nor the member states actually have jurisdiction. And this referral regime is not limited to a specific sector, but it also focuses in particular on the digital sector. And we have already seen cases being investigated under this new referral regime, 3 so far, and many more have been examined. But this is important to note here, this referral regime is currently being reviewed by the European Court of Justice and may be overruled. We expect the decision to be issued by the end of this year. Until then, however, it remains practice of the European Commission. And maybe with regards to the partnerships, they usually do not fall under merger control because in the EU, a notifiable concentration generally requires the acquisition of control. There are some notable exceptions where a minority shareholding can be sufficient, or in Germany, for example, also the acquisition of significant competitive influence. However, we have seen competition authorities like the EU Commission, like the CMA, but also like the German FCO, that have nevertheless investigated whether those partnerships should be notifiable under merger control. So far, the answers have been no, and authorities in the EU do not seem to be happy about these answers. So that we might see different ways of approaching these partnerships. For example, under the prohibition of cartels or the abuse of dominance. Maybe just to give 2 examples there. The Belgian and the French authority had already explored the way and investigated under the abuse of dominance whether a transaction that was not notifiable under the member state's law was unlawful. Again, the answer was so far no, but this is certainly going to be much more complex in the future.
So let's switch gears a little. Alana, I'm going to go back to you. We've heard the FTC talking about the connection between competition and consumer protection issues as they relate to AI. What should people know about that?
AI raises potential issues that are on the border between competition and consumer protection. For example, FTC Chair Lina Khan said earlier this year, she's given the example of firms that are engaging in privacy violations to build market power and then accumulating market power, which then enables them to violate consumer protection laws. How the 2 areas of law, antitrust and consumer protection, relate is not entirely clear from the agency's public statements, but it is something that we should be on the lookout for, this entanglement between the 2 areas of law and the potential for what typically we would view as a consumer protection violation. There's a potential for that to be investigated from an antitrust perspective too. As AI becomes more powerful and more prevalent, there are also likely to be increased consumer protection risks as well that are unconnected from antitrust concerns. For example, Biden's executive order on artificial intelligence from October of last year, it said that the federal government would enforce consumer protection laws and principles and also would enact safeguards against some of the risks from AI, such as fraud, unintended bias, discrimination, privacy infringements, and other harms. And we've already seen some high-profile examples of these consumer protection risks in practice, things like discrimination from a retail chain's use of facial recognition surveillance technology that it used for surveillance in its stores, and there was an FTC consent order in that case. There's also questions about how AI might introduce bias into hiring practices in a way that might exclude or adversely impact protected groups. There's also the risk of deepfakes and misleading AI content content, including things like scams and misleading advertisements and actual misinformation and disinformation, for example. And there are also legitimate privacy concerns from AI, with AI companies potentially using consumer data to train their AI models. FTC Chair Lena Kanzu has been that certain data, especially sensitive health data, geolocation data, and browsing data, is, quote, off limits for model training. But these are just some of the consumer protection topics we've seen to date, because we're really just starting to see this incredible power of AI and the innovations it drives and its more mainstream use. And with that, we are only just beginning to see some of the potential misuses and consumer harms from AI. So this really is a place to watch in the future.
Great, thanks, Alana. So let's turn from, we've been talking about theoretical antitrust risks, and let's turn to practical advice for clients. Chris, what can businesses do now to make sure that they don't run afoul of this new landscape as it develops?
Well, it's important to remember that this is a quickly developing area of law, so any particulars should be discussed with competition counsel. But that said, there are definitely a few best practices that will be good to keep in mind. The first is it's critical to understand AI models that your business uses, particularly if they're informing pricing, output, or other competitively sensitive decisions. And it's important to ensure independent decision-making is retained over these competitively sensitive terms. Understanding the sources of data that the AI model operates on is a key part of this. If your company's information is contributing to a data set that competitors can access with an AI or algorithmic tool, or if you're relying on such a tool that is taking in competitors' data, there may be some risk there. US agencies have expressed the view that users must be responsible for the pricing and output decisions of the AI tools that they use. In other words, the agencies don't see it as an excuse to claim ignorance if the models improperly facilitate pricing collusion or similar anti-competitive conduct. The contours of what is permissible here is still unclear, so it'll be important to engage with counsel and to keep abreast of developments as new court decisions become available. The second best practice tip is that companies should consider enacting and enforcing written policies for the use of AI tools, the analysis of company and external data, and the retention and access to that data. And this may include the use of firewalls to keep separate competitively sensitive information from different business segments that could be differently situated as to competitors. And the third best practice I'll note is for AI developers and companies that are in the tech space. And that's to plan ahead for regulatory scrutiny of any M&A activity or significant investments. They should consistently document pro-competitive and pro-consumer rationales for AI technology that's under development and for potential partnerships with other companies that are in this AI space. And at the product level, companies should be wary of sales strategies that could be perceived as limiting other firms' ability to compete on AI, particularly given the significant attention that's being paid to the industry.
Thanks, Chris. Alana, let me turn back to you. What about things like second requests and merger investigations or discovery and litigation? What should clients know about how AI can affect that?
It's a really good question. And it's important that we break out that question into two different buckets, because there really are two different issues here. One is the use of AI as a tool in a second request, a litigation and investigation. And I'll talk about that first. And the second is where AI is the subject of a second request, litigation, or investigation. On the first issue, the use of AI as a tool, there are a variety of AI tools that can be used in second requests, litigation, and other investigations. The tool that most of us are probably familiar with is TAR, Technology Assisted Review. It's a system that uses human review of a certain amount of documents to train the algorithm to rank or classify the rest of the documents, for example, about responsiveness. And there are different types of TAR, but that's generally how it works. Now, TAR is AI, but it's not what you might hear called as generative AI. Generative AI is really creating new content. TAR is just analyzing existing content. But there are generative AI review tools that could, if there's uptake, lead to an even bigger reduction in the burden and the lawyer time that are required for things like privilege logging that I know many of us have experience with. These tools offer the possibility of putting it in a document review protocol in a prompt of the AI tool, and then asking the tool to apply the coding and create the potential narratives for a privilege log, for example, to each and every document. That's something that is incredibly time intensive now and can be a huge cost for clients. These tools, these generative AI tools, they exist today, but they don't yet support the large amount of discovery in antitrust cases, but they're in process of being developed and expanded for use cases like antitrust. TAR can also be combined with generative AI tools that help analyze the massive amount of information produced in antitrust discovery. Our firm, for example, offers in-house legal tools, including a generative AI solution that can plug in to our document review platform, Relativity, and summarize documents and create chronologies automatically. That's a huge benefit if you have a big matter. It's a huge time reduction and cost reduction for clients if you have a very, very large matter. But when using AI or GAI as a tool, whichever you're using, it is important to be mindful of two potential risks in particular. The first one is that there's significant potential confidentiality concerns with AI tools. If you're going to enter a prompt into an AI tool, you want to understand whether the prompt, including any documents you input, are going to be used to train the model and potentially be disclosable to future users of the model. Second, if you're using a generative AI tool, the major risk is this risk of hallucinations. The generative AI system comes up with responses that are incorrect or misleading, or even entirely fictitious. And many of us have probably read articles with a little bit of horror about those cases in which lawyers filed briefs with courts that cited case law that a generative AI tool had identified, and the cases ended up being entirely fake. The generative AI tool hallucinated. That's still a potential risk here. Everything done by a generative AI tool still needs to be reviewed by a lawyer. Turning to the second issue, where AI is the subject of a second request, litigation, or investigation, there are important considerations when thinking about how to actually comply with a litigation demand or a complaint. One key question to consider at the outset is, what are you actually being asked to produce in discovery? Is it the source code? Is it the output of the model? Is it the training data? Is it the fine-tuning data? Is it all of the above? And there are likely to be significant disputes over the scope of discovery into AI and generative AI models, as well as disputes, frankly, over how to preserve and produce something that's dynamic and not static. And confidentiality concerns are also going to be important. The proprietary nature of AI and generative AI is likely to be a key issue in litigation and investigations over AI and generative AI solutions. It means that robust confidentiality protections and protective orders are going to be critical for defendants.
Thanks, Alana. Let me just stay with this topic for a minute and ask you about issues that we've heard a lot from agencies about, and specifically the use of ephemeral messaging apps and collaboration tools during investigations. What should people know about that?
So the FTC and DOJ announced in January of this year that they were updating language in their standard preservation letters and specifications for things like second requests, for example, to make it clear that companies have an obligation to preserve documents that were created through or in collaboration tools or ephemeral messaging. The announcement was driven by concerns that apps like Slack, Microsoft Teams, and Signal, and others have been used by employees to conduct work and are subject to subpoenas and second requests, but that companies are not preserving and collecting those documents. So the agencies warned in this January announcement that failing to produce documents, including data from ephemeral messaging and applications and collaboration tools, could result in criminal obstruction of justice charges. But the implications for second requests and other investigations and litigations really are, first, it's really important to ensure that individuals and the IT department are aware of preservation obligations. There is a risk of potential spoliation sanctions, and according to the announcement, potential referral to criminal prosecutors. And the second is a little bit more practical. Be mindful when you're producing these types of documents that come from ephemeral messaging apps and collaboration tools, because these tools, the discussions that happen in these tools tend to be more informal and off the cuff. So you probably should be on the lookout for documents that are more likely to be hot in antitrust lingo.
Yeah, great advice. Julian, how about you? What practical advice do you have for clients from an EU perspective?
Maybe there are two key takeaways. If we go to the next slide, one is think big about AI compliance. If you are an AI developer or if you use the AI, and then that can include rules on algorithmic design to restrict the way how an algorithm works to avoid the risk of collusion or algorithmic self-preferencing. Clients should avoid hub and spoke situations, or at least be very careful if common AI or data pools are used together with competitors. And it can, of course, also be very useful to include software engineers and IT experts in your compliance training. Regarding mergers, keep in mind that merger control gets increasingly complex in the EU. And also keep in mind that the authorities have a strong appetite in this area, and then plan accordingly. That means investigate at an early stage whether a deal may be a candidate for a referral under the Article 2022 regime, or could fall under a transaction value threshold in some member states, and reflect those uncertainties in the deal planning, in the deal documentation, as well as the timeline. And last but not least, try to always document the pro-competitive rationale of your deal in case it should be challenged by an authority.
So at this point, let me give out the CLE code. If we can turn to the next slide, it's summertime 2024 with a capital S. Summertime 2024. So please take a note of that if you need CLE credit. And this is the code you should use, and it will be the forms for this will be emailed to you again after the webinar. We have a few minutes left, and we have a few questions. Let me start with you, Chris. Chris, are there any indications of which industries are likely to be a focus for regulators with respect to the impact of AI on competition?
Well, I think there's risk to the entire economy, no matter the industry in question. And regulators are making clear that they think this technology could have a competitive impact in all sectors. But that said, there are a few industries that are prominent in regulator statements and actions to date. Healthcare, for sure, has been a focus, and so too, it seems, the creative economy. And in the tech space, the agencies suggest that they are looking at, I think as I mentioned before, the entire AI stack. It's a concept that they discussed earlier this month at a public workshop on AI issues. They're looking individually and as a whole at everything that goes into the AI technology, from the chips to the data, to the storage and networking, all the way from developer to user. And they're paying careful attention to potential harms to competition at each level of this distribution chain.
Okay. Julian, there's a question here for you. You had mentioned the potential impact on timing of the EU Commission's new referral regimes. How should parties deal with that?
Well, it's a good question. It's also a difficult question, and it can be difficult in practice as well. So my advice would be, and that may be the most important thing to consider at an early stage, whether the merger or the acquisition could be a candidate for such an referral. There is some guidance issued by the European Commission, which provides some assistance to identify relevant cases. How they are unfortunately relatively vague, and in particular, if a merger involves an AI startup or includes a strong incumbent, it may be useful or helpful to also consult with the European Commission. It explicitly offers this opportunity, and also reflect this in your timing. Parties should be aware of the long review period that comes with an Article 22 referral. It can take months until the final decision that a referral is being done or that a referral is being dismissed. And this is, of course, something that should be reflected in the contracts, for example, in long stop dates or condition precedents.
Got it. Thanks, Julian. Another hot topic today is data use and sharing and firewalls. Alana, so let me ask you, can you, and if so, how do you address AI models and firewalls or data use policies?
You absolutely can address an AI model in a firewall or a data use policy. It's more difficult than traditional places that we share information or that use information. It's not like a box of documents on your desk. To be able to address AI models in a firewall or data use policy, you need to understand a few things. What issue are you trying to solve? And you also need to have an understanding of the model or the algorithm, including what information the AI model is trained on. Is the data competitively sensitive or is it public? What information is the model sharing? In other words, what is the output of the model? The firewall policy can be developed, but it should be sensitive to the inputs and the outputs of the model, as well as how those are used.
Well, thank you, Alana. Thank you, all of us. We're just about at the top of the hour. So let me wrap things up here, but just by first thanking all of those in the audience for joining us today. I hope this was helpful. Remember that we're going to send out information about the CLE codes in an email after this presentation is concluded. And then finally, we do these quarterly. Our next one will be in September. So please keep an eye out for an email with the topic and date information. And I hope you can join us then too. Thank you all.